We back?
We're back.
All right. Welcome to another edition of Live Feed Reads. I'm your host, Paul Reed. My Ed McMahon to your left or right or on your screen, Jason Crawford. It is Friday, February the 18th.
Yeah, it
It
is.
is currently 79 degrees and cloudy in Tampa, Florida. I believe winter's over. I'm looking at the old forecast for Monday through next week. We've got 84 degrees, 87, 87, 88. Oh Lord. So
Jeez.
90 degrees is right around the corner. It's back to the beach. So, all right. Yeah, we're gonna jump right into today's topic, which is defamation for public figures and how that kind of equates to the appellate process and a few things that when I discussed it with Jason, he did not really know or was aware of. So
The
let's
resident
jump
idiot.
in. So uh,
Yeah.
when a public figure, in this case it was Sarah Palin, but any government official or public figure otherwise, it believes they're defamed, of course they can file suit against you. In the Sarah Palin case, which has been going on for a week or two or maybe three, there was a New York Times article back in 2017. See how long this takes? Back in 2017, which basically uh, indicated that her political rhetoric was somehow related to or resulted in a 2011 mass shooting. Okay, so the New York Times published an article. Sarah Palin thought that it was defamatory, and so she filed suit. Okay, the trial begins. Witnesses are put on the stand. At the end, after the plaintiffs put on their case, that's Sarah Palin. After the defense puts on their case, that's the New York Times. The jury goes off and they start deliberating.
So, for defamatory, do you need like to have suffered damages or something like that to be able to to,
Well,
to
let's
raise
not
a
forget
case or anything?
the I was going to put in here the
Is this one of those things where I just don't like what you said about me, so here's a
well,
lawsuit?
no, it's got to be egregious. It's got to be a false statement that defames your character. And yes, you do need actual damages, depending.
Okay.
So yeah, you just can't. I didn't like what you say. It's got to be pretty egregious. Um, in Florida, I believe defamation is called strict liability defamation. If you accuse someone of a felony, a sex crime, and a few other things of that nature, is defamation. But yeah, you have to say something pretty egregious.
Okay.
All right, and so basically accusing someone, their speech of resulting in a mass shooting would be defamatory.
Okay.
Uh, that was the argument anyway. So that the jury is out deliberating, and here's the problem that a couple of United States Supreme Court justices understand, or at least feel that's not related to the First Amendment, because the First Amendment protects the
Freedom of
newspaper.
speech.
Yeah, exactly.
Yeah.
That's Clarence Thomas and Neil, what's it, Gorsuch? I don't know how to pronounce his name, but they're saying that the standard is called malice, actual malice. They said that standard has no place in the First Amendment, and therefore public officials should not have to prove that the newspaper in this case uh, had actual malice when they printed the article. And the
Okay.
thing is, and it's here's a quote, and I'll tell you what actual malice is. Actual malice basically is that the newspaper, in this case, New York Times, knew that the article that they wrote was false, or they wrote the article with reckless disregard of whether or not it was false. And the comments by those Supreme Court justices and some of the others is that that's basically an immunity from liability for the publishers of defamation, because the standard is so high that it can rarely, if ever, be obtained by the plaintiff.
Okay.
All right, and that's been that was a Supreme Court case, a landmark Supreme Court case in 1964. So it's interesting that it's been around a while, but some of the Supreme Court justices, at least 2 out of 9, have commented recently that the standard should basically it was wrongly decided,
Huh.
believe it or not, back against the New York Times or for the New York Times, and it should be no longer part of the legal jurisprudence. Now,
Okay.
and interesting that the quote was that basically the bottom line, it seems,
This is your appointment reminder.
publishing without investigation, fact checking, or editing has become the optimal legal standard, i.e., ignorance is bliss. Well, I don't know. I didn't know it was a lie. I just published it. That's sad, but that's kind of how it is. Well, did you fact check, Jason, before you published this? Did you fact check it? No. Did you know it was wrong?
Well, don't.
No.
Well, don't. That way we don't have to be responsible for it.
Exactly.
Like, what the?
What? Right. So,
Whoa.
but okay, so that's what happened. But and so the jury's out.
Wow.
That's why basically
Jeez.
the public figures, and it doesn't have to be a public figure. Doesn't mean a governor or whatever. If you're Kim Kardashian or you're whomever, a public figure, it is who it is. A radio DJ, the list goes on and on.
Yeah, actually, I was thinking I might actually give you some, because there's a streamer called Ninja, and there's a couple of other people, and they've been back and forth in some of these same kind of lawsuits, and I'm like, you know what, I'm gonna give those to Paul and see if he can make sense of them, because I don't know what's going on with them, but I'll send them to you
That's
after.
what's going on. That
Be
basically, if you're a public figure, good luck.
Yeah.
All right. So here's what's interesting. So during the deliberations, the judge, it's a federal court judge in New York, basically says, "Hey, Ms. Palin, hey plaintiffs, you did not prove actual malice. I'm going to dismiss your case.
Okay.
But I'm going to wait to see what the jury does, what their decision is before I do so."
Okay.
Now you might ask, why would the judge do that?
Yeah.
Jason, why would the judge do that?
Yeah. Why would the judge do that? Yeah.
Well, I'll tell
Because if
you.
he already knows.
Your case is dismissed one way or the other. So right now, Sara Palin, you've already lost before the jury comes out. Because if they rule for you, I'm going to basically overturn that decision and dismiss your case because you didn't prove actual malice.
Got you.
The judge does that because if the New York Times wins, well, then his dismissal, he doesn't have to dismiss the case because the jury will have decided that either A, no defamation, the New York Times did not defame her, or that there was no actual malice.
Okay.
Which is what they did. So ultimately,
is that because he has like a better legal understanding
no,
than the deliberators?
Put it this way. Let's say that you're a criminal defendant in a trial, and there's a jury.
Yeah.
The jury finds you, based on the evidence, finds you guilty. Well, the judge can say, you had a good prosecuting attorney, and his speech was fiery, and it was hell and brimfire, and it really fired up that jury, and they ruled that you were guilty. But there was no evidence. There was not enough evidence. There was not evidence beyond a reasonable doubt. I'm going to overrule the jury, and you're not guilty.
Okay.
Now the judge can do that.
Okay.
Yeah, and that's what he
He's
did.
taking his life into his own hands, but yeah.
Yeah, he heard the testimony, and he right then and there could have granted like a directed verdict, meaning you didn't prove your case. And they do that sometimes, but with a high profile case like this that really had Supreme Court, United States Supreme Court implications, he was going to let it go. Because I got news for you. If Sara Palin had won and the judge had dismissed the case, the New York Times and or Sara Palin would have appealed. based on
Mm.
this actual malice standard, because litigants want to get rid of the actual malice standard because it's impossible to
To prove.
ever, it's nearly impossible to
Right.
ever find uh, against a
Mm-hmm.
public figure based on this standard. It just really is. So they want to get rid of it. And two Supreme Court judges have said that standard has no place in the First Amendment of the U.S. Constitution.
Okay.
And so then, boy, I'll tell you what, you would see an explosion of defamation suits
Sure.
against public figure or by public figures against
Against entities.
print entities, the
Yeah.
reporters, the internet, and things of that nature. As it
Sure.
is now, there's kind of free game, and unless the New York Times or the Tampa Times or whatever internet Times says, yeah, we knew it was false, which is never going to happen,
Yeah.
you're going to lose.
Yeah. Wow.
And one more thing I wanted to bring to the table. You hear people just say, well, if I lose, I'll appeal. Right? If the jury goes the other way, I'll appeal.
Right.
I'll appeal. It doesn't work like that. Just because someone doesn't like the verdict, one side or the other, you don't get to appeal. You don't get to just appeal because you lost.
Okay.
You don't get to rehash the facts at the appellate level.
So just because like I'm unhappy with the verdict and I'm like, hey,
you appeal, you can only appeal basically a judge's mistake. If he lets in evidence that you think should not have been let in.
Okay.
If one attorney or the other says things that are so inflammatory and you object, but the judge lets him keep going, and you feel that was the
grounds
reason
for
why you won or lost.
Okay.
You just can't say whatever the heck you want during a trial. Forget that crap you see on TV. I got news for you. When these lawyers on TV, they say something, they turn and talk to the jury, and the other party stands up and says object, and the judge says sustain, but you've already said it and heard it.
Right.
In real life, here's what happens, Jason. You say that inflammatory, shouldn't have been talked about rhetoric. Oh, the insurance company is whatever. I stand up and say, Your Honor, that's a mistrial. Mr. Crawford shouldn't have said that. He knew he shouldn't have said it. It's so inflammatory that it's now the jury's tainted, and the judge would say, yep, mistrial granted. Oh, Mr. Crawford, you got to pay for all the costs to date associated with this trial. Next time, keep your mouth closed. And I'll give you an example of that.
Yeah. Didn't that almost happen in the Rittenhouse case?
Oh, yeah. Yes.
Yeah. They were talking about that.
It's happened in one of my cases. A very nice guy, a friend of mine, was in Pasco County attorney, worked for Pasco County.
Okay.
And there was a motorcycle crash, and we pick the jury half the day. I give my opening statements because the plaintiffs go first, and this attorney goes second. So he's given his opening statements, and at the end, he out of nowhere says, and we're Pasco County. We ain't got any money. And we were suing Pasco County. And of course, the Pasco County residents are the jurors. And he's telling them, we ain't got no money. So the judge and I swear to God, the judge and I look at each other. He goes, Mr. Reed? I said, do I got to, Your Honor? He goes, let's go through the formalities. Motion for mistrial. Granted. So luckily, we just ruined or wasted a day picking the jury, and
and not the whole thing.
The defense lawyer, God bless him, he was younger, and he was like, "What happened? What I do?" And it's like, well, you can't tell the juror, Pasco County residents, that Pasco County doesn't have any money, so therefore you shouldn't award any money to the plaintiff. And I got to be honest, we all laughed. He laughed. He was embarrassed, but we all laughed. The judge was not, took it in stride. That's what happened. Listen, I'm telling you, these trials, especially when you're younger and you're just cutting your teeth, it ain't easy. It really isn't.
Yeah. And they seem like formalities or just like not loopholes, but
No,
like structure that you just kind of have to rigidly follow. But
there
I
is.
I see where it makes sense at the end of the day because it's about preserving I don't want to say the purity of the process, but it really kind of is about preserving the purity of the process so that whatever outcome, because there's going to be people who agree with the outcome and don't agree with the outcome either
Yeah.
way, but understanding that the purity of the process has been kind of adhered to, so we trust the outcome, and that trust
Well,
is important. So
well, that's it. It's just, you have to try your case on the facts. And
yeah,
so if you start talking about other things, i.e., that the county doesn't have any money or it filed
yeah,
bankruptcy, well, those aren't facts that have anything to do with this case,
right,
but they can influence the jury
yeah,
on how they decide. So, when you start your closing statement, closing arguments, and opening, you can't just go
yeah.
off on tangents. And here's another example.
We
What
can't
what you
award this verdict. It'll
Well,
bankrupt
it
the
was
city.
funny
You know,
back in the day.
that's nothing to do with the case.
The lawyers, the plaintiffs' lawyers, when they knew Allstate was on the other side, they'd say, "Oh, and you're in good hands." Well, that got booted pretty quick. And they
Jeez.
want you to think you're in good hands, ladies and gentlemen. Well,
Oh,
bye bye, mistrial. But that
oh.
was that was another one where
That's
nothing
so
to do.
snarky, though. Don't you
That
want to
had
say stuff
nothing to
like
do with
that?
the facts of the case.
So I would be a terrible lawyer because I'm way too snarky. Is that what you're saying?
Well, you would, if you continued, you would not be a lawyer. But yes.
Yeah, I
So
got you.
yeah,
I got you.
it's a fine line. You can, push the envelope, and that's really what makes
Yeah,
a good
yeah,
lawyer.
I've
But
seen that.
you
Yeah,
cannot go over the side and forget all that crap on TV. I
yeah,
mean, it's just
yeah,
that simple.
yeah. I remember
Uh,
when you represented me in that case where you were helping me defend, and that the other guy was just making himself right in front of the judge into a grade A yeah, the asshole,
yeah.
you know. And then that's not enough for a mistrial, but at the same, I don't wouldn't even, it wasn't a trial, but
Well,
it
and
was one of
remember,
those things where like, man, you got to be careful. You got to be careful how you
well,
say things.
it's strategy, because if you
Yeah,
don't, if one side or the other doesn't object, then you've waived
yeah,
your some of your arguments to the appellate court. But when
right,
you're trying a case, it's called a bench trial. There's jury trial and a bench trial. We had a bench trial with
right.
Jason.
Yeah,
Basically,
yeah,
some lawyer sued him because Jason did a bunch of work for him and then didn't want to pay him. And well, actually
yeah,
paid him, didn't want his money back or something. It was
yeah, yeah, yeah,
ridiculous.
yeah,
But so we were
yeah.
trying the case, and the guy, put it this way, we didn't stop him. Ryan, I think Ryan actually tried the case in one. We didn't stop him because he looked so bad and so ridiculous that we just let him go. And when you see the judge rolling their eyes and smirking at him and laughing, you just sit there and say,
And
wow.
watch the train wreck.
You watch the watch him go down in the quicksand, so to speak.
Yeah,
And
that was
that's
so
what he did,
that was
because
so
honestly,
good.
Jason, you would agree, it was just ridiculous.
It was. It was really disrespectful to her, to the judge
Yeah. So
as well.
anyway, we
But
won that
holy
one. But all
moly.
right, so
Anyway,
that's the Sarah Palin case.
yeah,
That's
okay.
actual malice. That's defamation. That's why you don't see it much with public figures, even though you hear a lot of probably false statements made about
Yeah,
them. It's just because it's
interesting.
basically almost impossible to prevail.
Yeah,
All right,
and
let
that's
me
kind of the
get
situation with appeals and stuff too.
yeah.
So that makes sense.
Let's get our
All our
weekly
words. Time
our
for the
words,
word of the
James.
day. Like I feel like Sesame Street, like
Word of the
the
day.
letter of
Yeah.
the day. Now I know she's gonna know
Okay, so that's
these.
the wait. All righty.
What happened?
All right, we
Oh, there
got
you go.
Leanne.
I know Leanne's gonna know these, so I'll like just
You're giving
simmer
Leanne
down,
a lot of
simmer
credit.
down. No, she's gonna know these. I
All
just
right,
know for
so
sure. All right,
what's the first word? And Leanne,
all
I'll
right.
go first. You go second.
We'll start with a softball, like an easy.
Mm.
All right, when someone calls you their bae, what does that mean?
Bae,
Yep,
I would think, boyfriend, girlfriend, someone they care about.
yep. Do you know what it means?
No, Leanne, you know what it means?
I mean, I would say, yeah, like your bae, like boyfriend or girlfriend, sure.
Okay.
Yeah,
But
yeah. But bae, BAE stands for something. Do you know what it stands for?
no,
Like babe. I don't know.
B, no,
I thought so
B-A-E.
too. I thought it was babe, and you just take out the second B. but I think that it stands for before anyone else. So it's your bay. It's your
Okay.
before anyone else. Someone.
All right. Well, I knew what it was. Let's go to number 2.
All right. Fine. All right. If you say bet,
Bet.
mm-hmm.
Well,
You know,
just I
bet.
bet would be. There could
Do you want
be
me to use
you're
it?
betting on something, or I bet meaning I'm right. Lee, hold on,
Close.
Leanne. What do you think?
No, it's like bet. Like, all right, I'll see you. Like, if you would be like, if you said, all right, bet. I don't know. It just
All right, bet. Like
What's
I'm
it
gonna
mean?
see you. I'm gonna see you later on tonight, and we'll grab some drinks. You're like, all right, bet.
yeah. All right, bet. Like, yes. Okay.
Oh, that's stupid. All right,
Like I
next
agree.
word.
Yeah, I know it's so. It's so.
All right, bet.
I mean, it's great for all of our young viewers.
Hey,
It's great. Keep
mine
doing
would
it.
be
Use
bet. Bet I don't.
it. Bet I don't. Bet.
All right.
Bet.
Okay.
All right. So
Bet.
here's another
Want
one.
to bet? Bet you won't see me because I'll be at the Hard Rock.
All right.
Go ahead.
Dead. If you say I'm so dead.
Well, of course, I would think tired or in trouble.
Okay.
Leanne?
It's the opposite. Oh
No,
shit.
It
Nope.
means like I'm dead. I'm laughing. It's so funny. I'm dead.
Yeah. Yeah, like that your dress is so cute. I'm so dead. Like that's so awesome. Like I feel so good about that, or I'm
Oh,
laughing.
ridiculous.
Yeah.
Okay, next word.
The last one.
Okay.
All right. My son says this one all the time. Yeet.
No, no idea. What's yeet, Leanne?
It means, well, there's a weird thing of it. Like, yeet can mean, I don't know, there's so many weird things.
Well,
It can mean, like,
Yeah.
keep it clean. We're on the internet, so to speak.
There's so many different things. It can mean, like, I don't know, honestly, how to explain that. It's a word people say. I don't even know how to explain it. You have to
Before
kinda
you
know
do
what I
something
mean.
crazy or exciting. Or like say
Yeah.
like if you threw the ball like really, really far, like you yeeted.
Yeah.
You yeeted the ball. It's like
I yeeted
you
it,
put like
yeah.
all your energy into it.
Ah,
Yeet.
stupid too. No, yeah.
But before you jump off of something crazy or hit a dunk tank or somebody dunks you in a dunk tank, you yell yeet. You're like yeet. And then,
Yeah, I don't think so.
Yeah.
All right, Beast, we're
Fair
out.
enough.
Yeah. All right, well, that wraps up this edition
Fair
of
enough.
Live Feed Read with Yeet. We will, God willing, we'll see you next week.
All right.
What is it? Freaking March is coming up. Oh my gosh.
Yeah.
Insane. Other than
It'll
that,
be the
Jason,
25th.
let's
It'll be the last one of the month.
say goodbye and we're out.
All right, we're out.